Shocking. Sarah Boone, shocking, I say, her motion to suppress her own 2-hour statement to police denied.
Who could have seen this coming? Sarah Boone's motion has been denied. I'm Lainey Law.
And I'm attorney Andrew Myers.
So Sarah Boone reasonably wanted to suppress her 2-hour, I believe, statement to the police, and shockingly, they're not letting that slide. So today we're going to be taking a look as to the details on that one, and I don't think anybody's surprised personally.
No, the judge pretty much showed his hand during the trial as he was pointing out to Sarah Boone's lawyer, James Owens, that the law just wasn't saying what he wanted to say. And the judge, I think, showed his hand, as I said, but he took a day to actually write a solid, well-cited order saying no, just pointing out that this cause came before the court October 2nd on the defendant's motion to suppress defendant's statements, filed on 9/24/2024. And then he goes on, talking about the procedure of it all. This court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, he's just telling the appellate court, I looked at everything, having reviewed the testimony and evidence offered by the parties, having considered the arguments offered by counsel for the state, and having considered the arguments offered by counsel for defendant, finds as follows. And we skip the part that our viewers all know.
And then over here we have C. Deputy Kayla Rodriguez arrived on February 24, 2020 and spoke to defendant. C also states Exhibit 1.
D. Detective Koepsell, a homicide detective with the Orange County Sheriff's Office, OSCO, with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of Jorge Torres' death on February 24th, 2020. Detective Koepsell arrived at the scene within 30 minutes to an hour of OXO deputies arriving, was briefed, and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted.
Detective Koepsell then made contact with defendant outside the apartment for a few minutes and explained the procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Koepsell wanted to go through the defendant's cell phone to corroborate the defendant's story. Defendant signed the consent prior to the February 24, 2020 interviews addressed below. See also defendant's Exhibit 1. Detective Koepsell did not look at the defendant's cell phone, including any videos prior to the interviews addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Koepsell then made contact with defendant's ex-husband, Brian Boone. Thereafter, detectives Koepsell and Lowen had an interview with defendant in Detective Koepsell's unmarked Nissan Pathfinder. I like that they specify.
Yeah, I noticed that a Nissan Pathfinder. How is that relevant?
In case you were wondering.
It wasn't a Toyota. No, it was a Nissan.
No, it was a Nissan. At approximately 5 p.m., C also stated Exhibit 1. Detective Koepsell explained that she wanted to have conversation with the defendant after walking the apartment. Detective Koepsell testified that she would not have interviewed the defendant outside of the unmarked vehicle, had no memory of using the words routine, and the routine is really getting I have to hear routine in this
it's
case,
routine to find somebody's boyfriend dead in a suitcase. That's routine.
Yeah,
you see that every day here.
I'm tired of the word routine. Get that out of there. And that everything was explained on the recording. The word routine is not used by Detective Koepsell in any recording. Oh, wow.
Detective Koepsell explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Koepsell, and Detective Koepsell's desire to get a further understanding of what happened last night and ask defendant more detailed questions. See states Exhibit 1. Thereafter, Detective Koepsell began reading the Miranda as follows, and this is important. Detective Koepsell, I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent. Okay, do it. No.
Yeah.
So you do have the right to remain silent. Okay, do you understand that? Sarah, yes. Detective Koepsell, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before question without charge. Now, this is an important sentence here. Has anyone threatened you or promised you anything to get you to talk to me? Sarah, no. Detective Koepsell, and this is a crucial sentence right here. Detective Koepsell asks Sarah, do you understand what I just read to you? Defendant, yes. So now they go through that colloquy again when Sarah is down at the police station the next day giving the 2-hour statement. So the judge is very, very thorough, footnotes, cites, everything. But we are going to jump down to the bottom where the judge really lays it on, whether the defendant's statements on February 25th were voluntarily made.
A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently, which is what we've determined from what they were saying, waives his constitutional privilege. And then they have.
Then they just cite all the
then
law.
they cite the law. Yeah, the same was proved by a preponderance of the evidence that the defendant's Miranda's rights were waived. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2, the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived.
And that's constitutional language right there, the totality of the circumstances revealing an uncoerced choice. But her attorney, James Owens, was really kind of stretching it, and the judge in that hearing on this motion was kind of trying to tell him. No, he wasn't kind of trying to tell him. He did tell him right outright that, the law does not go as far as you want it to go. And so paragraph Y, factors relevant to consider include 1, the manner in which the Miranda rights were administered, including any cajoling or trickery. 2, the suspect's age, experience, background, and intelligence. 3, the fact that the questioning took place in the station house. They weren't outside on the street. They weren't pushing her around. There was no, you sit down right now and, 4, the fact that the interrogators did not secure a waiver of the Miranda rights at the outset.
The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. There was no delay in the administration of the defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. Defendant acknowledged that she understood her rights. Evidence supported conclusion that defendant voluntarily waived right to remain silent, which, maybe she should have just stayed silent. And obtained counsel when officer read the defendant his rights and asked defendant whether he understood each of his rights, to which defendant responded affirmatively.
So the court comes down, surprise, 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 and there's no dun, dun, dun moment here. The court orders and adjudges as follows: the motion, the amended motion, and the second amended motion are hereby denied. Done and ordered in chambers. Yeah, where's my gavel? Done and ordered in chambers at Orlando, Orange County, Florida, this 3rd day of October, 2024. So, the judge is fairly clear on what he said. And the reason that he did not rule from the bench that day in that hearing is because he wanted a record. He didn't want some appeals court to say that, the judge was, acting summarily. The judge didn't have any legal basis. The judge didn't have any factual basis. So he goes into a legal analysis. And for those of you who want to go to law school, the legal analysis includes laying out the facts, laying out the law, applying the facts to the law, and coming to a reasoned, supported conclusion. It's called legal analysis, and the judge did that. Boy, did the judge do that. It's a fairly solid decision. I guess we can probably kind of guess that if Sarah Boone ends up getting a life sentence, there'll be an appeal. But I would predict, I've said before, I'll eat my hat, but one of these days I'll lose one of these and somebody will bring me in a hat. So I won't say I'll eat my hat, but, it was a fairly well reasoned decision. And it seems like the arguments that our attorney made just, he had to make them. I said before he had to make them because, you have a duty to zealously represent your client. But boy, was that a dud.
And it doesn't help to because I think and one of our commenters pointed this out, and it gives me war flashbacks when he's like, let me finish, when he was talking to the judge. And in the judge's defense, we go through cases sometimes where really questioning the judge, and I would say out of all the cases we've gone through, the judge in this one seems pretty reasonable, pretty level-headed. He was definitely giving them time to speak, but even when the defense was speaking, the judge multiple times pointed out that's not how that works, that's not accurate. Right. So we saw this coming, but
yeah, the part of the ruling that we skipped over, and it was really repetitive. The judge had to write it that way. I'm not criticizing the way it was written. I'm just saying that for the sake of brevity and not putting all of our viewers to sleep or losing them, the judge was very clear in making the analysis. But the judge also said that the Supreme Court has also said, the Supreme Court of the United States and also the Supreme Court of Florida have both said that there's no magic words. You've got to read the rights. And here's what the rights are. You have a right to remain silent. You have a right to an attorney. At any time, you can invoke that right. And I think anybody that watches, Lifetime TV knows that. You don't have to be past fifth grade to understand all of this. But Attorney Owens was injecting one final sentence that he saw on a card somewhere. And there is another sentence that he saw on a card somewhere. But the judge said, no, there's no magic words. It's absolutely crucial that you give the Miranda rights, and that you ask whether the person that you're going to take a statement from, do you understand those rights? And that's all. If you paraphrase it, it's not a good thing. That's why most law enforcement has a card that they read from. They have it in the squad car. They have it in the booking rooms, wherever the rooms where they take the statements. So the judge actually came out and said that this law enforcement officer, who I didn't think appeared all that well on the stand, I think that she didn't prepare herself well. She was stumbling. She wasn't sure of times. She wasn't sure of places. But despite all that, she did a good job in terms of Mirandizing the Sarah Boone. Mm-hmm. So, this was an argument about nothing. And I think that's why when the new attorney came on the case, the very last day of August, early September, he says, I'm just on the case. We need a continuance. The judge said, no, Sarah has engaged in enough antics, not his words, mine. Sarah has gone through 8 attorneys. And I think now we know why she went through 8 attorneys, because she wanted to go to the stand. And probably the 8 attorneys said, no, you're going to hang yourself. Well, she finally got an attorney that let her on the stand. What an awful appearance. I dare one person in the comments to tell me any points that she made that helped her.
Oh my gosh. The fact that, obviously, like you said, it's just we figured out the issue, and that clearly must have been something that she wanted to do. But, at the end of the day, and it's interesting because I did see we had a lot of mixed comments about it, but the attorney, he just got on this case. The case is about to start. Barely had any time to prepare, honestly. This is, he's just doing what he's supposed to be doing, and it's not surprising that he got denied. I can't imagine wanting to be in his shoes at all right now, because he has a uphill battle right now.
Here's my closing thought, and that is that as attorneys, we are all required to go to continuing legal education. In one of the states in which I'm a member of the bar, every year, in order to be renewed and to continue to practice for another year, we've got to take continuing legal education. Each year I have to verify that I've taken 12 hours. I often go over that because I find it kind of interesting sometimes. So you've got to do 12 hours. This case will, mark my words, this case will be taught in criminal defense CLEs, some of which I've gone to, as the lesson in never letting your client go on the stand. This is
Seriously.
here is Exhibit A in the CLE books as why you don't want your criminal defendant to go on the stand. They think they know everything. They think in their own mind they did nothing wrong, and they think they're going to tell the judge. You know how many times I've heard that? I'm going to tell the judge. No, you don't tell the judge anything. You argue your case. But anybody that says, I'm going to tell the judge, it's a bad day.
Yeah, I would, because I always tell, because you'll always meet people with overly ambitious ideas, and it's just kind of like, you got to settle down. And it's like, yeah, I know you have a great idea for an app, but there's a reason that the developers, went to school for however long they went to. In this case, you may think you have a great argument, but these legal professionals, like Andrew said, Andrew's doing 12 hours at least every single year. It's like, there's a reason these people are in the position that they are. They've done a lot of training. They know best. Don't argue. It's like, you obviously stand up for yourself and what you believe is right, but you got to trust your attorney to make the right decisions. And we don't know what went down behind the scenes, and maybe it was the attorney's suggestion, but from what it seems that Sarah wanted to speak her mind, and, she got that chance.
So, having said all of that, we hope you have a nice day. Thank you for joining us. Be sure to like and subscribe. And as I'm about ready to tell you, be nice. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.